you. I'll talk to some people while we're in there. Hey guys, Rogue Nation with you tonight. And tonight we're going to be talking about Price v. Garland. And we've got Merbeast, that's how I pronounce his name. Some say Merb 34th Street. And he does have a 34th Street gang he's notified me of. So we'll be talking about that tonight. We're going to wait a couple minutes, about a minute and a half, to let some people jump in here. Let's say hi to some of the folks. Callista, Peter, Juan Galt, Merbeast is in the chat. He shaved his nuts for the confrontation. Hebrew Hammer, good to see you, buddy. John, good to see you. Lou, our guy. The Colonel, a true Southern gentleman. Thank you, sir. Thank you for coming, guys. This should be pretty interesting. As most of you know, Merb's a lawyer. Six Oaks Farm. How you doing, buddy? Good to see you. So Merb's, I believe, 7 years practicing now, and he does general law. And if I remember him correctly, in his Discord, he said he's handling some family law issues. What other stuff do you have on your plate now, Merb? What other cases that you got going? I know you said you had some family law, but you also had some other stuff going, right? Contracts or
I am just a first-year family law attorney. I have no special knowledge about anything, and I have no experience outside of the family law arena.
He's trolling you guys now. A lot of people that go up against Merb, that's the first thing they say is that he's a first-year family law guy and that he doesn't know anything outside of his family law expertise. I got Press, we got John. All right, guys. So 2 minutes in, we got some folks in here. So Merb, do you want to start off? Because I had a minute to talk with you a little bit backstage about where you wanted this to go, and I'd like for you to take the lead on that, and then I'll offer my opinions up on it, and we can see if we can go from there.
Sure. So my position. So we're talking about Price versus Garland, which is a DC Circuit case. In Price versus Garland, Price was, for those of you who weren't aware of the case, Price was filming a documentary, and he was doing it in a national park. And the national parks, there is a statute that covers filming for commercial purposes in national parks. And essentially, you have to pay to film for commercial purposes, and you have to get a permit. Well, he ended up filming, and he didn't get a permit. And then some government agents showed up at his door with a criminal complaint in their hand, and they were asking essentially, they were going to charge him. They did charge him with filming without a permit, filming for commercial purposes without a permit. So he challenged the statute in the district court, and Instead of he challenged it for on constitutional grounds, and instead of defending the statute, the government decided just to let it go. They dropped the charges, and so he sued under for injunctive relief, for declaratory and injunctive relief in the DC Circuit or the DC District Court, and the DC District Court found that the statute was content based. Number one. And the district court found that since it was content based, it failed strict scrutiny, and even if it wasn't content based, it would still fail intermediate scrutiny. And so it went up to the circuit court, the DC Circuit Court, and they found a variety of things that I have an issue with. Number one, the DC court did not follow the steps set forth in Boardley versus the U.S. Department of Interior, which is a 2010 D.C. Circuit Court. And the three steps that they were supposed to take were set forth under Cornelius versus the NAACP, a Supreme Court case that set forth these three steps. And so the Supreme Court set forth the three steps that they were supposed to take, and then their own circuit in 2010 basically said, yes, we are actually taking these three steps, which they kind of had to do. And those 3 steps are: first, they have to decide whether or not the activity is speech that's protected by the First Amendment. Second, assuming it is protected speech, they have to identify the nature of the form. And third, they have to assess whether or not the government's justifications for restricting speech in the relevant form satisfy the requisite standard. The court in Price versus Garland did not do those steps. It did identify that it was protected speech, that filmmaking is protected speech. But then it stopped the analysis there. It just basically said, it doesn't really matter. It's not expressive activity, and so we're not proceeding. The next thing, so then we're on expression. This court is the only court that has made a distinction between prefatory kind of acts like writing a book, recording a movie, or filming a movie, writing a screenplay, and the actual expressive activity itself. They're prefatory acts, and so they're part and parcel. And so if First Amendment protection applies, it has to apply to the whole chain. This court fabricated a new test, whole cloth, with 0 citations to any other precedent, stating that, well, because this isn't expressive, it gets a lower level of protection. And so we're just going to give it a reasonableness standard. We're just going to say, reasonableness applies, which is another issue that I have, is that when the court decided that reasonableness applied, again, it just made it up whole cloth. It said, if it's going to apply in a traditional public forum or a designated public forum, because the statute does cover traditional public forums and designated public forums and non-public forums and limited public forums. It covers everything in a national park. And it said, it's just reasonableness. That's all we need. That's all we need for any of these forums, right? We don't have to do any other test for it. It's just a reasonable test. They didn't pick intermediate scrutiny. They didn't pick anything like that. And then finally, they played a little bait and switch game with content-based restriction. Now, a content-based restriction is from, it existed prior to Reed versus the City of Gilbert, Arizona. But in Reed versus the City of Gilbert, Arizona, the Supreme Court really made a point. If you have to look at the content, if you have to see what, in fact, they're writing on a sign or they're filming, then it's a content-based restriction. And a content-based restriction, it's strict scrutiny. So what does this particular statute do? It restricts commercial filming. So if you have to look to see what's being filmed, you're filming a drama. Well, now you're subject to the statute. Oh, you're filming for news purposes. Now you're not. Oh, you're filming for non-commercial purposes. Oh, well, it doesn't apply. If you have to actually look at what is being filmed, that's a content-based restriction. So what the court does is it plays fuck games, in the immortal words of Josh from Stone Vet. And what the court does is says, you argue, the Price argues that because the statute carves out an exception for news gathering activities, it's a content-based restriction, because everything but news gathering activities, all commercial speech but news gathering activities, are carved out. And then what the court does is it says, we've always had exemptions for the press. So what it does is it replaces a looking at what the content is versus who is making the content. It swaps those out, and it does it rather disingenuously. And so it says, hand wave it away, and we have this. We've always had exemptions for the press. We've always allowed them to do special things. The courts have always held that the press can do special things, and so they don't say how it would apply if, for example, the press, like Channel 6 News, came in and decided to shoot a drama in the middle of a national park. Do they get the news gathering activity exemption because they're press, or do they not because it's not news gathering activity? And then finally, the finality is what you'll probably call a slippery slope. And this is if any non-expressive content that's not immediately expressive can be forbidden just on a reasonableness test, like, if you're going to sit down and write a book, well, you're going to be blocking the path that someone might want to walk, and so you can't write books here in this national park. You can't do sketches in the national park. You can't paint a painting in the national park. It's not until you're going to display the painting that it's actually speech, right? Or someone comes in and they want to shoot a drama, right, or a documentary. All they have to do is live stream it now, and all of a sudden, bada boom, bada bing, it's expressive activity. Whereas before, same camera, just no internet connection. It doesn't make sense. So those are my big issues with it, and you can tell me where I'm wrong.
Um, well, I like a lot of your breakdown of it, and part of where I think that you're wrong is the expressiveness of the the filming, and the reason being is the test developed by Spence v. Washington about how to decide if an act is expressive. The first part is whether the individual performing the act intended to convey a particular message by the act, right? So I don't see someone like standing there holding a camera as somebody um, that is intending to convey a particular message by holding the camera, right? Like I can't go to Disney and see a guy holding a camera and know what his message that he's trying to capture per se is. And I think that's where it fails at, as far as recording and even live streaming, because when you're live streaming, you're not expressing your message to the people that's there in the forum with you. It is expressive in the fact, like you said, that it's going out and people are getting that message in real time, but they're not situated in that forum with you. So that's where I thought, because I know the footnote on Garland where it talks about live streaming and how it might be considered expressive. Um, but they also made the point that it's not in the same forum as they are. Now, when Price v. Garland came out, it made sense to me, right? Because commercial filming is regulated everywhere, not just the parks. You can't close off a city street to film Fast and Furious. You got to buy a permit. Whereas if I was to stand on the same street corner filming news activity, I wouldn't need a permit. Um, and they also made the point that in the recording cases that we do have, like Glick v. Knuff and Turner v. Driver, Fordyce v. Seattle, they never discussed the forum where the recording is made. Like there's no forum analysis in any of those cases that deal with recording. And the other part was because somebody said, well, if it's not expressive, then it doesn't have the speech protections of the forum doctrine. But I mean, what protected filming before the forum doctrine, right? What protected news gathering before the forum doctrine? Because there was news gathering before the forum doctrine, right? Like there was actual news broadcasts and stuff before the Supreme Court finalized the forum doctrine. I can't remember, what was it, Hague?
Hague is where the traditional public forum was set forth. Is that
Right? So
are you asking me, or is this part of
yeah,
your
no,
presentation?
I was asking you. I was asking you if there was, news gathering protections, recording protections before Hague, before the public forum doctrine created this protection for them.
Well, you have to remember that there's been a creep. When the 14th Amendment was passed, it didn't immediately apply everything in the Bill of Rights to the states. So there's been a creep over time, and also there was a massive preference to go to your state court to have these issues heard, because you got to remember every state has a constitution. Most states have a constitution that protects freedom of speech, right? So
Yes.
so a lot of this stuff can be resolved at the state level, and a lot of this stuff was resolved at the state level until it really you started seeing more and more of this in the civil rights era in the 60s and 70s, when people found that the state courts wouldn't be as as hospitable to rights as the federal courts were. So you saw a lot of this stuff really start to come out in the 70s. So before a lot of this, absolutely there were protections on freedom of speech and freedom of the press, and mostly it was protected by state courts and state constitutions.
Okay. Okay. Because a lot of people have said to me, hey, if you say that filming is not expressive, then you lose these protections of the forum doctrine. And my understanding was is that it's always been protected. Obviously before the 14th Amendment, you had the state constitutions, and if you were in the DC or the federal territories, then the Constitution applied to those folks only, as far as the Bill of Rights goes. So there was always that protection there. I didn't see the public forum doctrine as offering any protections that I don't think were already available. So that was my whole thing with the expressive thing, is that I don't think a part of a thing is the thing, right? Like you said, writing a book, if Tammy Faye Baker's in line to pay her utility bill, and she has a splash of brilliance and she wants to write down part of a sermon on a notepad while she's there, the writing down of the part of the sermon is not expressive in and of itself. Maybe she doesn't even use that part. Maybe she throws that part away, but it's still protected as being a part of the act of creating the whole thing. The same thing with like Stephen King. I mean, he could have never published a book, and none of his stuff would have been considered an expressive act because he didn't express it to anybody, right? Like, don't you have to like put it out in the world for it to be expressive?
Here's the problem that you're going to run face first into. The problem that you're going to run face first into is no other court, no other circuit court has ever drawn the distinction between expressive and non-expressive activity. Your case, Spencer versus Washington, is not. So what Spencer versus Washington is looking at it's looking at conduct, something that regulates conduct, kind of like burning a draft card or burning a flag. It's a conduct-based regulation that is also affecting speech. And how can you tell if it's affecting speech? Well, because speech is expressive, right? So buying a flag wouldn't necessarily be expressive. Is that speech? No. Even though it's prefatory to burning the flag, it's not speech. So your Spence versus Washington case is unfortunately an opposite. As far as commercial filming is concerned, there is a test for that. It's intermediate scrutiny, not reasonableness. So the test set forth was Central Hudson and Gas, Central Hudson Gas and Electric, Central Hudson something. It's Central Hudson test. It's a 4-part test. Basically, it has to look at whether or not it's lawful and truthful. If it skips that, if it gets past that, it's if the state can assert an interest, a substantial interest or a compelling interest, I forget which it is. It's something like narrowly tailored, but it's like designed or something like narrowly tailored, and then narrowly tailored and oh Jesus Christ. Hold on, I gotta look it up. It's an intermediate scrutiny test. If the speech is not misleading and governs lawful activity, the government may only regulate if, number one, the state can assert a substantial interest that is served by the regulation. Number two, the government regulation is designed carefully to directly advance the government interest. And number three, the regulation is not ineffective or remote in furthering that interest and is not more extensive than is necessary. So it's a 4-part test that Price could have used, but no one uses a reasonableness test in this particular field, and no other Supreme Court decision has looked at whether or not the conduct is expressive. Indeed, Garland versus Price, they say quite near the beginning. Hold on a second, let me get there. Scroll up. It's right near the beginning of it. They agree. Right there at 1067. filmmaking undoubtedly is protected by the First Amendment. Filmmaking, not showing a film, not distributing a film, not watching a film, not playing a film. Filmmaking undoubtedly is protected by the First Amendment. So you're saying that it's a prefatory act. Well, Price versus Garland undermines their own argument by saying, yeah, the prefatory act is undoubtedly protected by the First Amendment. And then they're like, oh, fuck the rest of the test because we're gonna lose it. They reverse engineered this entire decision to essentially allow the government to control the commercial filming, but they don't actually do any of the analysis. They don't do the analysis for the forum analysis. They don't do it. They just completely disregard Broadly, and they completely disregard Cornelius. I want to say Cornelius. It's not Cornelius. It is Cornelius versus NAACP. They completely disregard it. They completely disregard their as far as the content-based analysis, i.e., if it's the content that is being looked at, which it is, then it's strict scrutiny. So what they do is they play fuck games. Again, they're like, okay, we're not gonna even address the content-based approach of, hey, is this commercial or not commercial? They don't even attempt to look at that. They completely bypass that, and they say, "Well, but you make an argument that because we allow news gathering activities, that's important. There's to the extent that you're doing news gathering activities, blah blah blah, but you're not. So I mean, you could be doing a drama or a documentary or whatever. So then they go into, well, we've always allowed exemptions for the press, which is a thing, not an activity. So they just ignore both tests that they were supposed to apply, the content-based test and the forum test. They completely ignore them, and they just shit out this whole new reasonableness test that, again, they have no citations to. Let's look it up. I mean, let's go down to where they bring it out. Under section B at 1071, right at the end of the page, they start their reasonableness test. And if you look that whole paragraph, there's only one citation, and that's to the district court case. That's to the district court case that they are overturning. So they are literally, they have no basis in precedent to make up this test. They literally just crafted it whole cloth, and it doesn't make sense. Because if you can stop someone from filmmaking in a tradition, even they did some other disingenuous shit. Like they looked at Alvarez, right? They looked at Alvarez and they hand waved it away. Where am I at? Scroll up. They looked at all the cases that the petitioner raised. On. And they said all but one of them. Here we go. Right at the bottom of page 1070. The cases Price cites do not establish a general right to create recordings in public places. Save for what? All those cases deal with the filming of a public official, usually a police officer, performing public duties on public property. Well, the problem is you've got the ACLU versus Alvarez is one of those, right?
And the wiretapping one.
No, ACLU versus Alvarez. Let's deal with that first. ACLU versus Alvarez. Number one, they were looking to record their own people. Hold on a second. Let me find it in the case. They were looking to record their own people in addition to the cops. Scrolling.
Oh, that's right. They wanted to have like some kind of not setup, but some kind of like activity to where they went around recording the police, right? The ACLU did, and they said that they couldn't because of the statute, the wiretapping, eavesdropping statute.
So they planned on making audio-video recordings of policing at expressive activities carried out by its members. So they were literally going to do expressive activities for the purpose of filming the police. But what does the court call it? The court calls it expressive activities. The court calls it audio and video, or audio and audiovisual recordings are media of expression commonly used for the preservation. This is on page 588. For the preservation and dissemination of information, ideas, and thus are included within the free speech and free press guarantee of the First and 14th Amendments. So that's a problem for them. That one of the cases they're citing, they completely ignore the fact that ACLU versus Alvarez called it expressive activity. What they're saying isn't expressive activity. ACLU versus Alvarez is calling expressive activity. And then you also have Fordyce versus the city of Seattle, which is actually the case I was thinking of, that the court didn't cite. And why didn't the court cite Fordyce? Fordyce is one of the OG ones, right? It was one of the earliest ones. And what happened in Fordyce is that Fordyce was filming people, not the cops, people. Now the cops came up and hassled him initially, but when the cops actually arrested him, he was filming people. He's filming. Let's look it up. Let's look it up. So this is at 438 on Fordyce versus the city of Seattle. At the end of the day, in a separate incident, a different officer arrested Fordyce when Fordyce, attempted to videotape some sidewalk bystanders against their wishes. That's what Fordyce was arrested for. Not filming the police, generally filming in public. He was filming sidewalk bystanders.
Yeah.
And what did the court say? The court said he had a right to do that. All the court was looking at now was did the police have notice that they couldn't violate his First Amendment rights?
Now, did Price quote Fordyce in the complaint there? I don't remember seeing that in there.
They didn't, and the court didn't address it. Now, why didn't the court address it?
Well, isn't it true the court's not going to offer you a defense that you don't bring up? Like, they're not going to say, hey, well, you didn't offer this case law, but I know from, my experience as a judge that Fordyce versus Seattle fits in here.
Well, here's the problem. A lot of the cases that they do cite Fordyce.
Okay.
So it's in there, even if it's not expressly in there.
Okay.
And there was another thing. Hold on, let me see if I have a note on it.
Now, I do want to say that I have found some cases that do say that recording is not expressive and lacks sufficient communicative elements. And I'll quote those whenever you'd like to look those over.
Oh, okay. So the final thing is that you said that none of the cases cited do a forum analysis. Well, Colorado versus Care Donkey Watch.
Yeah.
Colorado Donkey Watch. They said it's a forum analysis, and way back, even before Colorado versus Kerr, I was saying that the Bato side didn't understand his own case, Turner v. Driver, because that reasonable time, place, and manner restriction that is typically applied in a public forum, a traditional public forum. The one oddball, the one circuit that has not made it into a forum-based analysis is the First Circuit. The First Circuit's the oddball with Glick and Garricky. But all right, so let's look at some of your cases. Let me. All right, I'm ready. Hit me with one.
Okay. The first one is Kelly versus Borough of Carlisle. It's the Court of Appeals for the Third Circuit, and they determined that video recording lacks sufficient communicative elements to trigger the protections of the First Amendment. In Kelly, the plaintiff surreptitiously videotaped a police officer during a traffic stop. The Third Circuit suggested that a citizen may offer evidence that recording is linked to speech about public affairs. However, the act of recording is not sufficiently expressive or communicative, and therefore not within the scope of the First Amendment protection, notwithstanding that the subject is a public servant. And that says ID at 261, citing Pomkazy versus Borough of West Wildwood, 438 F Sup 2D 504 2006. And then it says, additionally, the First Circuit affirmed the finding that capturing an image is information gathering and does not partake of the attributes of expression, and that's D. Amaro versus Providence Civic Center Authority. In that case was
Hold on 1 second. You didn't give me a page citation on the Kelly versus
on the Kelly. It says ID at 251.
No, what page is your site on?
Oh, it doesn't say. I'm reading from a brief here, so all I've got is, sorry, Merb. All I got's the quote and the case number is all.
Did you write that brief?
No. This
Who
is
wrote the brief?
Hold on, I'll tell you. Let me go up to the top here. It's Brittany Earnhardt, Nicholas Schilling, Jeffrey Schmidt. It's for the Harry Piper versus Luna Lockwood. It's Satori to the United States Supreme Court.
When was that brief written? I'm going to guess prior to 2017.
Let me see. I don't think it said. No, it doesn't. It doesn't say. Okay.
Because in 2017, the Third Circuit Court of Appeals decided Fields versus the City of Philadelphia and Geraci versus the City of Philadelphia. They both decided that a person has a right to film or photograph police in public. So those are actual circuit court cases, not a district court case like Kelly was.
But didn't Kelly Fields was 2009.
I'm sorry?
Okay, but didn't Fields also say that without criticism of the officer that it was not expressive?
Where's that citation at?
I'm pretty sure Fields said that. If there's no again, I'm just getting it from this brief, so I guess maybe this brief is after 2017 because it does reference Fields. Let me get back to where I was. Hang on. Yeah, it says in Fields, the district court upheld the arrest of multiple citizens for violation of a law prohibiting recording of police officers. In upholding the law, the court observed that absent some element of expressive conduct or criticism of police officers, the simple act of recording police without otherwise declared expressive intent is devoid of any First Amendment protection. And then it just says 166 F Sup at 537.
So then why didn't you cite to Fields instead of to a district court case?
I was just reading it as it came up in the brief, is all.
Okay. So it does appear that the Third Circuit is a deviation. It does appear to have some deviation, but it appears that they're saying that you actually have to say something in the video. Now, if you're recording the police and you say something, or shooting a documentary and saying something, then wouldn't that be expressive conduct? Wouldn't they both be just as expressive? Because here in Fields, they're not saying that if you are recording, it's not expressive. They're saying if you're recording without saying anything, it's not expressive. So
Right, but and that's, what's the line there? So let's say I'm recording, right? And I'm
right.
recording on a street corner, and somebody walks by and says, "Hey, what time is it?" And I say, "Oh, it's 10:30."
Hmm.
Does that meet the test for an expressive activity now because I talked while I was recording? Or does it have to do with the message that I'm trying to express only? Right? Like, if I'm standing on the corner and I'm holding just a blank, like Jeff does, he's got the cardboard sign, but my cardboard sign is blank, am I being expressive?
Maybe. I mean, just conducting a sit-in, just sitting down someplace has been expressive activity.
In Brown, right?
There's been multiple cases where sit-ins have been expressive activity.
Okay. Was it that protesting the fact that they weren't allowed to sit in there, or they were?
Sit-ins sit-ins generally speaking have been held to be expressive activity.
Okay, so if like me and you were to just sit in the park, that would be expressive?
No, uh,
Okay.
it would it would depend on our purpose. If we're doing it to protest, they can the court can look at your purpose. Again, conduct the court can look at, is it expressive?
Right, so
Con
people would, yeah,
conduct.
people would have to look at you to be able to get your message and understand it for it to be expressive, right?
Not necessarily. I mean, is it expressive to burn a flag in on a city sidewalk if there's no crowd there? Your intent is to display a message. Your intent is to send a message.
Right.
Just because no one comes by to look at it, does that make it not expressive anymore?
Well, no, because if people did come by and see it, wouldn't they see the message or would
If
realize
they
what the
did,
message is?
if
Well,
they
right. I
did,
mean,
sure.
I don't think you have to have people around you for it to be expressive, but I mean, there has to be a message that people can garner from what you're doing in order for it to be expressive. Like, I can't imagine walking by and seeing 20 kids, just sitting in a park and being like, "Oh yeah, that's expressive," because there's
So
20 of them and they're sitting there.
so it appears that having had a chance to peruse Fields while we were talking, it appears that Fields is looking at filming as conduct, and so it's applying the conduct analysis to filming. So if that's the tact that Price was going to take, which they didn't, then that would be something, but they did not. They didn't. They started off again. The fucking problem with Price is they start off with filmmaking is undoubtedly First Amendment protected. Undoubtedly, filmmaking is undoubtedly. So we could skip right past everything else. So in Fields, they're saying, is this expressive activity? I.e., is this speech? Is recording speech? It's conduct. It's not speech. It's not speech until you actually intend to convey a message with it, right? That's what they're saying. They're looking at it as conduct. Price doesn't do that. Price doesn't say, filming is conduct. Therefore, blah blah blah. It's saying this is speech. We understand it's speech. They could skip that whole step on whether or not this is speech, because what Fields is looking at is whether or not the First Amendment applies. So Fields says the First Amendment doesn't apply. So the Third Circuit has said the First Amendment doesn't apply to filming the police if that's all you're doing. If you're not actually criticizing them or expressing anything, if you're just filming, it doesn't apply because that's conduct. Fields or Price says filmmaking is speech. It is First Amendment activity. Do you see the difference between those two things?
Yes, I do. Hold on one second. Somebody gave me a super chat. I missed it. Thank you, whoever that was. I appreciate it. And sorry,
That
I hadn't
was
been.
DFK for Justice, who says, "Thank you for your help spreading knowledge on the First Amendment." Thank you.
Well, Merb doesn't take sides. Merb doesn't like me, but Merb's a firm supporter of the First Amendment. Um, and you know, I listened to him a couple of weeks ago. He did a live stream. I think it was a great live stream. He talked about the fact that, the First Amendment is not meant to protect a message that we all agree with, but rather, something that maybe we don't agree with. And so I thank Merb for that. Now, I don't have the law degree that Merb does, and as everybody knows, and I learn by myself, through my books, and through cases and through talking with lawyers other than Merb. You guys know I got a good buddy, Vince, who's a lawyer, 30 years, that we talk all the time about the stuff. But um, it's nice to talk with other people, and Merb, he gives what he gets, and he'll tell me, hey, you're wrong, dude. So I like that. As you guys know, I don't like echo chambers. I like people to tell me I'm wrong, so that way I could maybe change and possibly better myself. So um,
Michelle raises a good point. Michelle says, so you have to say it in the camera and say you are protesting. No, Chile is always almost in the field of something, almost. So in the Third Circuit, apparently, if you're like, I disagree with what you're doing, police, that would be enough. You don't have to say you're protesting. Just saying you're protesting probably wouldn't be expressive enough. Maybe if you say I'm protesting you doing whatever it is you're specifically doing, maybe. But you should probably say it. If you're in the Third Circuit, you should probably say, I disagree with what you're doing, police. I am voicing my disapproval. Sorry, I didn't mean to hijack your show.
no, absolutely. Thanks for explaining that. Um, I think it's wrong when we don't try to keep learning, right? And nobody knows it all, and everybody has something to teach. If we only just take a little bit of time um, to learn. So I want to thank you for that, Merb, and I'm sure the guys in the chat appreciate that as well. Um, but yeah, again, with the whole case and what I'm looking at, and what the direction I'm going with my cases is that it's not expressive. Filming in and of itself is not expressive, just like writing a book is not expressive.
What
Um,
circuit are you in? You're in 11th Circuit, right?
yes. So my whole First Amendment outlook is more classical, I guess you could say. So the 1774 constitutional, uh, the Congress wrote a letter to the inhabitants of Quebec. They were talking about the right to free press, and they said that the right to the free press was the right to shame our public officials into doing what's noble. All right. So also Justice Cooley in General Principles of Constitutional Law, 1898, pages 301, 302, stated that, you know, we're supposed to keep an eye on these public officials, the elected ones and the ones that are not elected. We're supposed to keep an eye on these people and report back to the citizens their actions, so that way the citizen is informed of, who's running their lives, right? So like in the Fourth Circuit with the City of Easley case, um, the Fourth Circuit said, well, you don't have, there's not a Fourth Circuit case that gives you a right to film the police. But my answer back to them was, why would I need a case when the whole right to free press is the right to watch over our public officials and report that information to the citizens, right? Because, I mean, correct me if I'm wrong, but back then, the most important thing and probably the most reported on thing was the government, right? Thomas Paine, Benjamin Franklin, these guys were all writing about the government. They weren't writing about the new pop singers tour, or, the New York Giants or anything of that nature. They were focused on reporting what the government was doing, um, the legalities of it, and that sort of thing. Um, what do you think on that, Merb? Am I good there, or am I off on the rails?
I have to be honest with you. I completely zoned out. Anytime people start talking about the past and the founders and things like that, that's not really relevant to what is current case law. Current case law is current case law, and what it was in the past was relevant in the past, and it's not so relevant now unless there's a case that you could cite that is the current case law on it. So a lot of people, a lot of anytime you see someone going to like what Thomas Paine said or something like that, that means they don't have a case. That means that they have an argument that is unsupported, and it's a bad place to be.
Well, I mean, isn't it true that the intent, the judges go back to find out what the intent of the statutes were and the laws? Ain't that how they decide what that law
So
is supposed to mean?
all right, so the first place that a court will look to decide what the law is supposed to mean is prior rulings, specifically prior rulings, preferably of a higher court than them, i.e., that is stare decisis. So you're in the 11th Circuit. So an 11th Circuit ruling or a Supreme Court ruling, that's the most preferential thing. Then they're going to look at other decisions, either a district court case or a case from another circuit. That's the second thing they look at. The third thing they look at is the statute itself. The fourth thing that they're going to look at are treatises like practice guides or Prosser on torts or something like that. The next thing that they're going to look at is going to be the legislative history. So we've gone a long way down to look at the legislative history, and what they're looking at there is they're looking at what the legislature said when they were passing this particular bill. So you've gone a long way down, and then even below that, they're going to look back at the way back history of it, like what did the founders say about this? Because what you're saying is, by the time you get down there to what did the founders say, you're saying there aren't any cases on point that are precedential. There aren't any cases on point that are at least kind of helpful in deciding. The statute itself is unclear on it. The practice guides don't mention it or don't give any real good input on which way we should go. The legislative body didn't really say a lot about it, why they were doing it, what they intended to achieve, how they intended it to be interpreted. And so now we're in the Wayback Machine because it's the last resort before the court has to just make shit up, right? So that's why I'm kind of dismissive on it, because like even when you look back at the Wayback Machine, I mean, the Wayback Machine is, and by the Wayback Machine I mean like history in general. Number one, if a court is going to do that, a court is going to find examples in the past that support what the court wants it to be. The court's not going to look into their Wayback Machine, into all the history and stuff, and find all the stuff that doesn't support the position they want. That's just number one, the nature of humans, and it's the nature of courts. If you're looking, if we had a anti-gun Supreme Court when Heller was decided, we would have gotten an entirely different version of history. It would have been entirely different. They would have been talking about what the English did, right? They were talking about how it was okay. The English were actually trying to take our guns before the Civil War, and this and that, like all this stuff about how it's just baked into common law. And this state did this, and this state did that. It would have been an entirely different outcome. So the court's just going to make it up. If you're trying to convince a district court with what was going on back in the colonial era, it's not a good argument. It's not a winner.
No, but if you could show like a pattern, like say from the very beginning, okay, all the way up, legal scholars all the way up the line have said the right to free press is the right to record our public officials and bring that information to the citizen.
You remember where I was talking about learned treatises?
Yeah.
That's what you just said. We're not talking about the Wayback Machine. Right now, you're just described a learned treatise where you look at some law review article where someone has done all the Wayback stuff up to now that says, like, these are all the cases that kind of come up with this. But I still caution you that learned treatises are low down on the list, because for every learned treatise that supports what you want, there's going to be another learned treatise that says, no, this isn't the way it goes. Because who writes these learned treatises? Individuals who are trying to get to an outcome. And the court's going to pick the one they like the best.
Okay. Now, the reason I brought up the intent of the law was because, and you brought up Gilbert, And in Gilbert, they specifically say that even if the statute is content neutral, that you need to look at the intent to see what the legislation really wanted. Because they said that a lot of times it looks good, I guess, on its face as being content neutral, but the legislature really wanted to do something else, and they just hid it under this way. Like for example, um, in um, in Pasco County right now, there's a statute. It's called um, dangerous use of the median, right? But really, the legislator enacted that law to deal with panhandling, right? So if you were to go to a cop in Pasco County and you were to say, "Hey, what's the panhandling statute?" They would give you the code for the dangerous use of uh, the public median. So even though that's what the law says, the legislature, the police, they're using it against panhandling to try to get around the panhandling law.
I
Wasn't that the
believe you have
same
it.
thing in
I believe
Gilbert?
you have it backward. I believe you have it backwards.
Okay.
The court of appeals wanted to say, it's content neutral because the town did. I mean, they didn't have. They weren't trying to undermine anything or whatever. But the Supreme Court said, no. The first step of determining whether something's content neutral is to look at whether or not you can make a determination without looking at the content. That's on page 228. So, or no, 2228. This analysis skips the crucial first step in content neutrality analysis, determining whether the law is content neutral on its face. If you have to look at the content of the sign to determine whether or not you're in violation of the ordinance or not, it's not content neutral.
Okay, so with that in mind, would you say that the Punta Gorda ordinance is content based, which is a lot like the Easley, South Carolina ordinance, where they both restrict recording of non-consensual employees? Because it says in the statute it restricts recording of non-consensual employees. You can record the walls, you can record the floors, you can record the consenting employees, but you can't record the non-consenting employees. Wouldn't that be a content-based restriction?
Sorry, I have had a quite a bit of a 9.5% beer, so
You're
the
fine.
the thinker isn't moving as fast as it probably should in this situation. Now, I remember vaguely the case. It was not decided that it was a content based restriction. So let me see if I could puzzle out why without actually pulling up the case. Uh, so the reason why filming, for example, a commercial film as opposed to a non-commercial film, the reason why that is content based is because you have to look at what is being filmed. You're gonna have to look at like the end product, um,
Well, okay, for
as
example,
opposed to filming someone. Well, obviously, if they know they're being now, got it, because at the end of the day, now that I remember the case, it came back to me. The restriction is such that the mayor will ask the police to, or they'll inform the police, and so they are not making a decision on what the content is, and then the police, I believe, can trespass you or not if you're. It was something about them passing it off. They aren't actually like stopping you from recording. All they'll do is tell the police. That
you
was why
talking
it wasn't.
you talking about the South Carolina one?
I don't remember. I'm a bit of a lightweight. I apologize.
No, no,
Uh,
no. You're fine. And the reason I'm asking is because let's say I was to go in either place, Punta Gorda or into Easley, right? Both of them
right,
have the same restriction against unconsenting employees. And
right,
let's say I have my camera out, okay,
right,
and I'm waving it around.
right.
How can they prove that I violated the statute without looking at my recording device and seeing if I've actually captured unconsenting people? But even more so, what if I didn't even turn the camera on? How would they decide if I violated that statute without looking at my recording device?
Right. So how would they determine that? I'm going to we're a little bit far off of Price versus Garland. I'm just going to say
I
that right now.
yeah.
How would they prove that? Well, so how they would prove it, I'm going to assume, would be an employee would say he pointed his camera at me. That's what you did. You pointed your camera at me. Uh, how you would enforce it would be like, don't point your camera at employees. Uh, are you restricting the content of what someone can film? Sure, but then it goes down to a strict scrutiny uh, review. It's not unconstitutional right off the bat. Uh, but assuming that they are actually stopping you from recording, it's going to come down to whether or not there is a compelling government interest. It's rationally related to achieving that compelling government interest, and it's the least restrictive method available for achieving that rational or that compelling government interest. So, is there something that they could do to prevent you from filming other employees that is less restrictive? Probably not. Is there a compelling government interest? Uh, I'm going to say that there probably is. Probably because the government is going to want its employees to be able to perform their jobs and not be distracted. They're paying these people to do this stuff. I'm going to say that a court could probably rationalize a compelling government interest. Is it narrowly tailored to achieve that compelling government interest? Sure. Don't film them without their consent. So if they're bugged by it, they could say, "Don't film me." But again, this is kind of hypothetical. The courts haven't seen it this way. The courts haven't determined it was a content-based restriction, and so I'm kind of off in the weeds. Without a specific case to look at, I'm kind of off in the weeds.
Well, right. The Sheets case has been the only case that's been brought against Punta Gorda, as far as I know, for the ordinance, and my case is the only case so far that's been brought against Easley. So there's no cases on it as of yet, per se. Um, but I just wanted to get your take on that because again, I, the statutes don't say pointing a camera in their direction. It says recording.
Right,
So they you know what I mean? Because like I got a camera on the back
right,
of my phone. So if I'm talking
right,
on the phone and I'm walking around, I'm pointing it at my camera at them. You know.
right. And
So
so look at how simple it is for you when they're like, "Hey, don't record him." You're like, "Hey, look, I'm not recording." They're like, "Oh, sweet, we'll carry on. Problem solved. Case closed."
right, but they'd have to look at what I have on my device, right, in order to.
No, they wouldn't have to look at the content of what you're recording because you were specifically not recording in that example.
But how would they know I wasn't recording?
Because you could show them. Just like if they're like, "Hey, there's no talking in here," and you're like, "I wasn't talking." They're like, "Oh, okay, cool." Right? Are they judging you by the content of what you're saying? No, it's they were saying, "Hey, don't record her," and you're like, "I'm not recording at all." Okay, cool. You're not recording.
So I'd,
That's
I'd
not
have to show I'd have to show them what was on my device,
no. I
or
mean,
that my
you're
device is
you're
off.
you're, you're showing them that you're not recording. You're not
Right,
showing them the content of what you're recording because you weren't recording anything.
right.
There's no
So
speech there to protect. You're trying to do a First Amendment analysis on something where there's no speech to protect. You're literally saying there's no speech here. First Amendment. Sorry.
that's fine. That's fine. Um, I think I think that was where I was pretty much headed off at. We've been on about an hour. Um, did you have something more you want to discuss on Price v. Garland before we? Because we did go off a little bit on the side there.
They claim reasonable articulable suspicion. You should be given a chance to dispel their suspicion. They're not detaining you. I'm looking at Blind Justice. Oh, your chat's fun. No, I mean I've made my points. I hope I was convincing.
Yeah, no, I appreciate that you come on here. Like I said, there's always something to learn. So
Is John Black says, is Merb a bootlicker? I've literally taken the side where the government was overly intruding on your right to free speech in Price versus Garland. And this dumb motherfucker asks me if I'm a bootlicker. Jesus Christ. Oh, I love people in these chats. Sorry. I
you're
should
fine.
probably go.
Yeah, Merb's not a bootlicker or an auditor supporter. He doesn't take sides. He gives his opinion on how he sees things. So
Actually, no. I'm going to correct you on this because I normally wouldn't, but I'm going to correct you on this. I love the freedom of speech. I got into this field. I became an attorney because I was in the comment section on First Amendment auditors arguing in favor of them. The problem was there's a lot of dumb motherfuckers out there in the First Amendment auditing community who don't know the law, who misunderstand the law, who misapply the law, and then who wonder what the fuck just happened when they end up in cuffs. And so I start telling these people, hey, this is what you're doing wrong. But I don't have I don't have a law degree. So I'm like, you know what? At one point, I'm like, I'm enjoying this. I'm going to go get my actual license to practice because I had a law degree, but I didn't have a license to practice. So I went and I got my license specifically because of First Amendment auditing and First Amendment auditors. I don't like police. I don't like police. Police are way too fucking intrusive. They think that their dick is the biggest in the room, and they walk into every situation and they want to control it. They want to control you. They don't want to be nice. They don't want to act just like Joe Blow. They want to be like, I'm in fucking charge. You're going to do it my way. And they shouldn't. And I don't like it. I don't like cops. I don't like cops. My neighbor was a cop when I moved in here. Probably within a week of knowing him, I'm telling his son, don't ever talk to the police. Don't trust them. They'll lie to you. Right in front of this motherfucker's face. Now, he's a good dude. Like, my neighbor's a good guy, but he's a cop, and you don't trust him. And you know what he said to me? He didn't say a goddamn thing. You know why? Because he fucking knows that outside of this county, his son is just another piece of shit. Yep. And any other cop out there is going to fuck that kid over and make him talk and say dumb shit and incriminate himself. And he fucking knows that. And so he didn't tell me I'm wrong. He didn't tell his son, oh, you know what? He's a dumbass. He didn't say. So am I a bootlicker? You know what? Go fuck yourself. We have way too many laws in this country. We have way too many impositions on our freedom in this country. Why the fuck is it a problem if I walk into some place with a camera? I get it. There might be some places where they have sensitive information out, but if it's not, why the fuck do you care? Like, really, why the fuck do you care? 99 times out of 100, if the auditor wasn't being an asshole, you could walk in recording with no problem. 99 times out of 100. But there are some people who are going to make it a problem that one time out of 100 where you're not being an asshole, and you walk in with the camera not being an asshole, someone's like, why are you filming me? And they make a scene about it. Why? Who the fuck cares? So I'm a statist. Yeah, I'm totally a statist, bro. So anyway, no, I'm not technically neutral in this. I don't like the police. I don't like all the excessive controls on our government. I am much closer to James Freeman than James Freeman would want you to believe. However, I understand that there is a state. I understand that there are armed men with guns who are going to enforce these laws. And I think it is better for me, for you, for everybody, if we all understand these laws. And we understand how they're going to be enforced, not how they should be enforced, but how they are going to be enforced. Not how I want them to be enforced, but how they are going to be enforced. And so that's all I'm doing. I'm just trying to tell you, this is how the laws are going to be enforced. Whether you like it or not, whether I like it or not, whether Rogue Nation likes it or not, this is how they're going to be enforced. I don't like it, but this is the way it is. And men with guns are going to enforce it. So anyway, Blind Justice says, I think I'd like to have a chat with this Merb guy. The last time we tried that, Blind Justice, you pulled some douchebaggery and you prematurely ended our conversation. So I don't think that's going to help. Anyway, sorry. I keep hijacking.
No, dude, you're fine. All right. Well, I got to get out of here. I got to cook for the fam, and and get them going. But I definitely appreciate you coming on and talking with me about it. This has been a case that was just decided last year, so it's new and in everybody's mind. So, getting some information out on it, I think, could only help people. So,
if you're not
yeah.
in the District of Columbia, it won't really much affect you. But yep.
Well, right. All right. Well,
It
have a
was
good
good talk.
night.
Thank you. You have
Yeah,
a great night.
absolutely. Everybody in chat, thanks for coming. Thanks for the donation. Um, and we'll see you guys again. Let us know what you think in the comments section. All right. Now say goodbye to everybody for public safety. One man, Wanda, Narnia, Douglas Fox, Michelle, Blue Steel, Blind Justice, of course, Cliff, Gray Dude, NWO Know It All, George Daly, Wrights Krispies up in the house, Northwoods. All right, guys. Thanks everybody for coming out and checking out what was had to be said. You guys know my stance on it is that what was said tonight and what you guys hear all the time. So um, I guess time will always tell. That's the great thing about it. Time will always tell what the law is, and it'll work itself out. So, all right, guys, we'll see you next time.